May it please the Court, Chief Justice, I am Asanda Deepa and I appear for the applicant.
Thank you, ma'am.
Thank you.
Chief Justice and Justices, I rise on behalf of the first and the second respondents.
Thank you.
Chief Justice, Deputy Chief Justice, Justices, my name is Yanela Ntloko, a pupil at the Johannesburg Bar. I appear with Ms. Delunga Sio on behalf of the Economic Freedom Fighters, the fifth respondent.
Thank you.
Chief Justice and other my name is Lizelle Adams and I'm here for the eighth respondent.
Thank you, ma'am.
Chief Justice, Justices, Michael Powell on behalf of the first and the second amicus curiae.
Thank you.
Good morning, Chief Justice,
Morning.
Deputy Chief Justice, and other justices. My name is Maipato Shata, and I appear on behalf of the fourth amicus.
Good morning and thank you.
Morning, Chief and Justices. My name is Cindy Balimakara from Webo Insular Attorneys. I appear on behalf of the Third MAK Institute for Security Studies. It pleases the Court.
Good morning to you too and thank you. This is a unanimous judgment that I have written in which Acting Deputy Chief Justice Ngabinde, Justices Cameron, Froneman, Jafta, Khampepe, Madlanga, Mtlantla, Mujapelu, Pretorius, and Zondo concur. It is about whether the Speaker of the National Assembly has the power to prescribe a secret ballot as the voting procedure for conducting a motion of no confidence in the President. The following context is essential for a proper understanding of the reasoning and outcome. South Africa is a constitutional democracy, a government of the people, by the people, and for the people through the instrumentality of the Constitution. It is a system of governance that we, the people, consciously and purposefully opted for to create a truly free, just, and united nation. Central to this vision is the improvement of the quality of life of all citizens and the optimization of the potential of each through good governance. Since constitutions and good governance do not self-actualize, governance structures had to be created to breathe life into our collective aspirations. Hence, the existence of the legislative, executive, and judicial arms of the state. They each have specific roles to play and are enjoined to interrelate as foreshadowed by the following principle that guided our constitution-making process. I quote, "There shall be a separation of powers between the legislature, executive, and judiciary, with appropriate checks and balances to ensure accountability, responsiveness, and openness," close quote. Knowing that it is not practical for all 55 million of us to assume governance responsibilities and function effectively in these three arms of the state and its organs, we, the people, designated messengers or servants to run judges and magistrates. Judges are selected by a constitutional body which comprises members of parliament from the ruling and opposition parties, a few judges, a cabinet member, a few legal practitioners, a university law teacher, and the president's appointees. Of the candidates who prove to be fit and proper for a judicial vacancy at the level applied for, one is then appointed by the president. And like all other accountable servants of the people, their underperformance or sanctionable conduct could result in their removal from office through an impeachment process if the judiciary, parliament, and the president so decide. The people representatives in parliament are chosen through an electoral process. Each citizen qualified to vote may participate in that process that is designed to deliver free and fair elections. Those who stand for public office and are elected must then attend the first sitting of the National Assembly. It is at that first sitting that at least three things over which the judiciary presides must happen. First, members of the National Assembly must be affirmed or sworn in. Second, the Speaker of the Assembly must be elected by members. Third, members of the Assembly must elect the President of the Republic, meaning two arms of the state, the judiciary and parliament, each has a different but critical role to play in the process of electing the head of state and head of the executive after general elections. Thereafter, the president must be sworn in by the Chief Justice, and that oath comes with serious obligations. The president is an indispensable actor in the proper governance of our republic and bears important constitutional responsibilities. To enable him or her to discharge these obligations, he or she has a fairly free hand in assembling the service delivery team, another set of servants comprising the deputy president and a number of ministers and deputy ministers required to exercise national executive authority of the republic. They may be dismissed by the president. Public office in any of the three arms comes with a lot of power. That power comes with responsibilities whose magnitude determines the allocation of resources for the performance of public functions. The powers and resources assigned to each of these arms do not belong to the public office bearers who occupy positions of high authority therein. They are therefore not to be used for the advancement of personal or sectarian interests. Amandla awethu manda ndiashu matla kiaruna or matimba yahina. Power belongs to us, and Maibuya in Africa, restore Africa and its wealth, are much more than mere excitement-generating slogans. They convey a very profound reality that state power, the land and its wealth all belong to we the people united in our diversity. These servants of the people are supposed to exercise the power and control these enormous resources at the beck and call of the people. Since state power and resources are for our common good, checks and balances to ensure accountability enjoy preeminence in our governance system. This is all designed to ensure that the trappings or prestige of high office do not defocus or derail the repositories of people's power from their core mandate or errand. For this reason, public office bearers in all arms of the state must regularly explain how they have lived up to the promises that inhere in the offices they occupy. And the objective is to arrest or address underperformance and abuse of public power and resources. Since this matter is essentially about executive accountability, that is where the focus will be. Accountability, responsiveness, and openness enjoin the President, Deputy President, Ministers, and Deputy Ministers to report fully and regularly to Parliament on the execution of their obligations. After all, Section 42(3) of the Constitution tells us that Parliament, open quotes, is elected to represent the people and to ensure government by the people under the Constitution, close quote. It thus falls on Parliament to oversee the performance of the President and the rest of Cabinet, and hold them accountable for the use of state power and the resources entrusted to them. And sight must never be lost that, open quotes, all constitutional obligations must be performed diligently and without delay, close quote. When all the regular checks and balances seem to be ineffective, or a serious accountability breach is sought to have occurred, then the citizens' best interest could at times demand a resort to the ultimate accountability ensuring mechanisms. Those measures range from being voted out of office by the electorate to removal by Parliament through a motion of no confidence or impeachment. These are crucial accountability enhancing instruments that forever remind the President and Cabinet of the worst repercussions that could be visited upon them for a perceived or actual mismanagement of the people's best interess. Whether that time has come and how exactly to employ any of these instruments is the judgment call of the same Parliament that elected the President and to which he or she accounts. Some parliamentarians believe that that time has come and have tabled a motion of no confidence in the President. They have themselves invited this court to get involved and clarify the nature and extent of Parliament's power. Rightly so, because, open quotes, everyone has the right to have a dispute that can be resolved by the application of law, decided in a fair public hearing before a court, close quote. Implicit in this application is a deep-seated concern about just how effective Parliament's constitutionally prescribed accountability enforcing mechanisms are. Do they ensure that there are enforceable consequences for failure to honor core constitutional obligations? Or is it easy to escape consequences by reason of the inefficacy of mechanisms? And does the Constitution, read with the rules of the National Assembly, give the Speaker the power to prescribe voting by secret ballot in a motion of no confidence in the President? First, a brief background. What reportedly triggered the tabling of a motion of no confidence in the President is that on 30 March 2017, invoking his constitutional powers, the President dismissed the Minister of Finance, Mr. Pravin Gordhan, and his deputy, Mr. Mcebisi Jonas. Very soon after their dismissal, our economy was downgraded to a sub-investment grade, otherwise known as junk status. And it was largely because of the economic downgrade that three of the political parties represented in the National Assembly, the UDM, the DA, and the EFF, asked the Speaker of the National Assembly to schedule a motion of no confidence in the President. She agreed and scheduled it for 18 April 2017. On 6 April 2017, the UDM wrote a letter to the Speaker. She was asked to prescribe a secret ballot as a voting procedure for the scheduled motion of no confidence in the President. In response, the Speaker said voting procedures in the Assembly are determined by the Constitution and the rules of the National Assembly, and that none of them provides for a vote on a motion of no confidence to be conducted by a secret ballot. She also placed reliance on the Kawama decision as a further ground for concluding that she lacks the authority to prescribe a secret ballot and for dismissing the UDM's request. Aggrieved by that response, the UDM, supported by some of the political parties represented in the National Assembly and friends of the court, approached this court to determine whether the Constitution and the rules of the National Assembly require or permit or prohibit the Speaker to direct the vote on a motion of no confidence in the President to be conducted by a secret ballot. It also seeks an order directing the Speaker to arrange that a motion of no confidence be held by a secret ballot not later than a particular date. The jurisdiction of this court is sought to be established on two alternative grounds: direct access and exclusive jurisdiction. We would do well, in our view, having regard to the provisions of Section 167(6) of the Constitution, to leave the resolution of the question whether this court has exclusive jurisdiction in this matter for another day. Here we embrace and reiterate the observations relating to the importance of a motion of no confidence in our constitutional democracy, its primary objective as an effective consequence enforcement tool, and the likelihood of a dispute ending up in this court, even if we were to direct that it be heard by the High Court first. A motion of no confidence in the head of state and head of the executive is a very important matter. Good governance and public interest could at times hemorrhage quite profusely if that motion were to be left lingering on for a considerable period of time. It deserves to be prioritized for attention within a reasonable time. The relative urgency of the guidance needed by Parliament from this court is also an important factor to take into account. Consistent with the approach we adopted in the Mazibuko case in relation to an application for direct appeal, we too find it convenient to resolve the jurisdictional issue on the basis of direct access. And based on the factors highlighted above, we are satisfied that it is in the interest of justice that we grant direct access to this court. On the nature and purpose of a motion of no confidence and the correct approach to be adopted in search for answers to the issues in this matter, we have the following to say. The preamble to our Constitution is characteristically terse, but profound recordal of where we come from, what aspirations we espouse, and how we seek to realize them. Our public representatives are thus required never to forget the role of this vision as both the vehicle and directional points desperately needed for the successful navigation of the way towards the fulfillment of their constitutional obligations. Context, purpose, our values, as well as the vision or spirit of transitioning from division, exclusion, and neglect to a transformed, united, and inclusive nation led by accountable and responsive constitutional office bearers must always guide us to the correct meaning of the provisions under consideration. Our entire constitutional enterprise would be best served by an approach to the provisions of our Constitution that recognizes that they are inseparably interconnected. These provisions must thus be construed purposefully and consistently with the entire Constitution. Although a motion of no confidence may be invoked in instances that are unrelated to the purpose of holding the President to account, it is a potent tool towards the achievement of that purpose. In that context, it is inextricably connected to the foundational values of accountability and responsiveness to the needs of the people. It is a mechanism at the disposal of the National Assembly to resort to whenever necessary for the enhancement of the effectiveness and efficiency of its constitutional obligation to hold the executive accountable and oversee the performance of its constitutional duties. And accountability is necessitated by the reality that constitutional office bearers occupy their positions of authority on behalf of and for the common good of all the people. It is the people who put them there, directly or indirectly, and they therefore have to account for the way they serve them. A motion of no confidence therefore exists to strengthen regular and less fatal in quotes accountability and oversight mechanisms. To understand how a motion of no confidence in the President and how enhances and fits into the broader accountability scheme, it is necessary to understand sections 92 and 93(2), which are of the Constitution, which are some of the constitutional accountability provisions that apply to the executive. Members of the national executive, namely the President, Deputy President, Ministers and deputy ministers are thus enjoined by the supreme law of the land to be accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions. Not only are they responsible for the proper exercise of the powers and carrying out of the functions assigned to them, but they are also required to act in line with the Constitution. Additionally, they are obliged to, in quotes, provide Parliament with full and regular reports concerning matters under their control. In anticipation of a President's and this constitutionally envisaged team's possible remissness in the execution of their constitutional mandate, provision was made to minimize or address that possibility. Those who represent the people in Parliament have thus been given the constitutional responsibility of ensuring that members of the executive honor their obligations to the people. Parliament that elects the President, and of which the Deputy President, ministers and their deputies are members, not only passes legislation, but also bears the added and crucial constitutional responsibility, in quotes, of scrutinizing and overseeing executive action. Members of Parliament have to ensure that the will or interests of the people find expression through what the state and its organs do. This is so because Section 42(3) of the Constitution says Parliament, open quotes, is elected to represent the people and to ensure government by the people under the Constitution, close quotes. This it seeks to achieve by, among other things, passing legislation to facilitate quality service delivery to the people, appropriating budgets for discharging constitutional obligations, and holding the executive and organs of state accountable for the execution of their constitutional responsibilities. The National Assembly indeed has the obligation to hold Cabinet accountable, put effective mechanisms in place to achieve that objective, and maintain oversight of their exercise of executive authority. There are parliamentary oversight and accountability mechanisms that are sufficiently notorious to be taken judicial notice of. Some of them are calling on ministers to regularly account to portfolio committees and ad hoc committees and avail themselves to respond to parliamentary questions, as well as other question and answer sessions during a National Assembly sitting. It is also through the State of the Nation address, budget speeches, and question and answer sessions that the President and the rest of the executive are held to account. These accountability and oversight mechanisms are the regular or normal ones. There may come a time when these measures are not or appear not to be effective. That would be when the President and his or her team have, in the eyes of the elected representatives of the people, to whom they are constitutionally obliged to account, disturbingly failed to fulfill their obligations. In other words, that stage would be reached where their apparent underperformance or disregard for their constitutional obligations is viewed by elected public representatives as so concerning that serious or terminal consequences are thought to be most appropriate. And that takes the form of removal from office. The Constitution provides for two processes in terms of which the President may be removed from office. First, impeachment, which applies where there is a serious violation of the Constitution or the law, serious misconduct, or an inability to perform the functions of the office. Another related terminal consequence or supreme accountability tool in between general elections is a motion of no confidence. A motion of no confidence constitutes a threat of the ultimate sanction the National Assembly can impose on the President and Cabinet should they fail or be perceived to have failed to carry out their constitutional obligations. And it is it is one of the most effective accountability or consequence enforcement tools designed to continuously remind the President and Cabinet of what could happen should regular mechanisms prove or appear to be ineffective. This measure would ordinarily be resorted to when the people's representatives have, in a manner of speaking, virtually given up on the president or cabinet. It constitutes one of the severest political consequences imaginable, a sword that hangs over the head of the president to force him or her to always do the right thing. But that threat will remain virtually inconsequential in the absence of an effective operationalizing mechanism to give it the fatal bite whenever necessary. A motion of no confidence is, in some respects, potentially more devastating than an impeachment. It does not necessarily require any serious wrongdoing, though it is implied. It may be passed by an ordinary as opposed to a two-thirds majority of members of the National Assembly. Unlike an impeachment that targets only the president, a motion of no confidence does not spare the deputy president, ministers, and deputy ministers of adverse consequences. And the Constitution does not say when and on what grounds it would be fitting to seek refuge in a motion of no confidence. As to when and why a motion of a point could be, I beg your pardon, I'll start again. As to when and why a point could conceivably be reached where serious fault lines in the area of accountability, good governance, and objective suitability for the highest office have since become apparent, those concerns might not necessarily rise to the level of grounds required for impeachment. But the lingering expectation of the president delivering on the constitutional mandate entrusted to him or her might have become increasingly dim. In the final analysis, the mechanism of a motion of no confidence is all about ensuring that our constitutional project is well managed, is not imperiled, the best interest of the nation enjoy priority in whatever important step is taken, and our nation is governed only by those deserving of governance responsibilities. To determine through a motion of no confidence the continued suitability for office of those who govern is a crucial consequence management or good governance issue. This is so because the needs of the people must never be allowed to be neglected without appropriate and most effective consequences. So, a motion of no confidence is fundamentally about guaranteeing or reinforcing the effectiveness of existing mechanisms in between the general elections by allowing members of parliament as representatives of the people to express and act firmly on their dissatisfaction with the executive's performance. But does the Speaker have the power to prescribe a secret ballot as the voting procedure in a motion of no confidence in the President? Put differently, do the Constitution and the rules of the National Assembly require, permit, or prohibit that voting in a motion of no confidence in the President be by secret ballot? Section 102.2 provides that the National Assembly has the power to pass a motion of no confidence by a vote. No section or rule supports the contention that a secret ballot is required or provides expressly for any voting procedure in a motion of no confidence. But several important observations emerge from sections of the Constitution that provides for voting. The procedure to be followed for the election of the President and several constitutional office bearers, even at a provincial level, has been specifically provided for. It is voting by secret ballot, and whoever secures a majority of votes is to be declared elected. As regards the removal from office either through an impeachment or a motion of no confidence, the Constitution is silent on the procedure. The Constitution could have provided for a vote by secret ballot or an open ballot. It did neither. Why did the Constitution not prescribe the voting procedure in a motion of no confidence? Absent an express constitutional choice, the National Assembly is at large to exercise its Section 57(1) powers to decide on the appropriate procedure in terms of which to vote on the motion. And the choice lies between an open ballot or a secret ballot. The National Assembly, therefore, has the power to determine whether voting on a motion of no confidence would be by open ballot or secret ballot, informed by what would best advance our constitutional vision or project. Both possibilities of an open or secret ballot are constitutionally permissible. Otherwise, if members always had to vote openly and in obedience to enforceable party instructions, provision would not have been made for a secret ballot when the President, Speaker, Chairperson of the National Council of Provinces and their deputies are elected. And the Constitution would not, I beg your pardon, and the Constitution would have made it clear that voting would always be by open ballot. If the will of political parties were always to prevail, the Constitution would probably have required of political parties to determine which way they want to vote on issues, and through their chief whips signify support or opposition by submitting the list of members who would be present when the voting takes place. But because it is individual members who really have to vote, provisions are couched in the language that recognizes the possibility of majorities supporting the removal of the President and the Speaker. Conceptually, those majorities could only be possible if members of the ruling party, of a ruling party, are also at liberty to vote in a way that does not always have to be predetermined by their parties. And this, of course, assumes that the ruling party would generally be disinclined to the removal of their own. It bears emphasis that the absence of a prior determination of the voting procedure by the Constitution for a motion of no confidence means that it neither prohibits nor prescribes an open ballot or secret ballot. The effect of this is to leave it open to the National Assembly when the time comes to vote on that motion, to decide on the appropriate voting procedure. This can only reinforce the conclusion that the Assembly has the power to make that determination. It is for it to decide on the voting procedure necessary for the efficiency and effectiveness of the institution in holding the executive accountable. In sum, how best and in terms of which voting procedure to hold the President accountable in a particular instance is the responsibility constitutionally allocated to the National Assembly. The Assembly has made rules in terms of its Section 57 powers. Those rules make provision for the determination of the voting procedure for a motion of no confidence. Though, I beg your pardon, through its rules, it has in effect empowered the Speaker to decide how a particular motion of no confidence in the President is to be conducted. Rule 104, 1 and 3 of the National Assembly empowers the Speaker to have a motion of no confidence in the President voted on by secret ballot. But as to when a secret ballot would be appropriate is an eventuality that has not been expressly provided for and which then falls on the Speaker to determine. It is her judgment call to make, having due regard to what would be the best procedure to ensure that members exercise their oversight powers most effectively. And this is the approach that is demanded by and accords with separation of powers. Next to be addressed are factors that ought to exercise the mind of the Speaker in determining the appropriate voting procedure. The proper exercise of the power to prescribe a voting procedure in a motion of no confidence proceedings would partly depend on why the Constitution prescribes a secret ballot for the general elections and a contested election of the President and the Speaker. As is the case with general elections where a secret ballot is deemed necessary to enhance the freeness and fairness of the elections, so it is with the election of the President by the National Assembly. This allows members to exercise their vote freely and effectively in accordance with the conscience of each, without undue influence, intimidation, or fear of disapproval by others. The frustration or disappointment of the losing presidential hopeful and his or her supporters could conceivably have a wide range of prejudicial consequences for members who are known to have contributed to the loss. To allow members of the National Assembly to vote with their conscience and choose who they truly believe to be the best presidential material for our country without any fear for reprisals, a secret ballot has been identified as the best voting mechanism. Conversely, a member of parliament could be exposed to a range of reasonably foreseeable prejudicial consequences when called upon to pronounce through a vote on the president's accountability or continued suitability for the highest office. But of course, that potential risk would also depend on the motivation for the motion of no confidence. Is it on grounds that impugn competence, faithfulness to the Republic, or commitment to upholding constitutional obligations, or on some fairly innocuous or less divisive or less sensitive grounds? The appropriateness of a voting procedure for that motion is particularly important since our electoral system is structured in such a way that it is, broadly speaking, a party but not a member of parliament that actually gets voted into parliament. A political party virtually determines who goes to parliament and who is no longer allowed to represent it in parliament. Members' fate or future in office depends largely on the party. The deputy president, ministers, and deputy ministers are also members of parliament. Who are also members of parliament are presidential appointees. The ruling party has a great influence on or dictates who gets appointed or elected as senior office bearers in parliament. Almost invariably, the president, although not a member of parliament, is the leader of the ruling party. It would be quite surprising if the senior office bearers in parliament are not appointed or elected with a significant input by the president and other senior party officials. There are therefore institutional and other risks that members, particularly of any ruling party, are likely to get exposed to when they openly question or challenge the suitability of their leader or leaders for the position of president. I say leaders advisedly because the logical trend has been to give the highest positions in governance structures to most senior leaders. Addressing this occasional tension between party loyalty and the need to vote according to conscience in the certification case, this court made observations set out in broad terms below. The most effective extra-parliamentary mechanism for holding the people's elected representatives accountable is a general election. It is in this context that this court said that, open quotes, it is parties that the electorate vote for and parties which must be accountable to the electorate, close quote. Also, that a party's unacceptable abandonment of its manifesto is likely to result in electoral defeat, and that a factor that is relevant to the Speaker's decision-making in relation to a democratically permissible voting procedure is that, open quotes, an individual member remains free to follow the dictates of personal conscience, close quote. Central to the freedom to follow the dictates of personal conscience is the oath of office. Members are required to swear or affirm faithfulness to the Republic and obedience to the Constitution and laws. Nowhere does the supreme law provide for them to swear allegiance to their political parties, important players though they are in our constitutional scheme. Meaning, in the event of conflict between upholding constitutional values and party loyalty, their irrevocable undertaking to in effect serve the people and do only what is in their best interest must prevail. This is so to enable the people to govern through them in terms of the Constitution. Also, that a party's unacceptable abandonment of its manifesto is likely to result in electoral defeat, a factor that is relevant to the Speaker's decision-making in relation to a democratically permissible voting procedure. There's a repetition for which I apologize. When the risk that inheres in voting in defiance of the instructions of one's party is evaluated, it must be counterbalanced with the apparent difficulty of being removed from the assembly. Openness is one of our foundational values, and the assembly's internal arrangements, proceedings, and procedures are required by the Constitution to have due regard to the need to uphold the value of transparency in carrying out the business of the assembly. The electorate is at times entitled to know how their representatives carry out even some of the most sensitive obligations, such as passing a motion of no confidence. They are not supposed to always operate under the cover of secrecy. Considerations of transparency and openness sometimes demand a display of courage and the resoluteness to boldly advance the best interest of those they represent, no matter the consequences, including the risk of dismissal for non-compliance with a party's instructions. These factors must also be reflected upon by the Speaker when considering whether voting is to be by secret or open ballot. Some consequences are adverse or injurious, not so much to individuals as they are to our constitutional democracy. Crass dishonesty in the form of bribe-taking or other illegitimate methods of gaining undeserved majorities must not be discounted from the Speaker's decision-making process. Anybody, including members of Parliament or of the judiciary anywhere in the world, could potentially be bought, in quotes. When that happens, in a motion of no confidence, the outcome could betray the people's best interest. This possibility must not be lightly or naively taken out of the equation as a necessarily far removed and negligible possibility when the stakes are too high. For when money or oiled hands determine the voting outcome, particularly in a matter of such monumental importance, then no conscience or oath finds expression. The correct exercise of Parliament's powers in relation to a motion of no confidence in the President must therefore have the effect of ensuring that the voting process is not a fear or money-inspired sham, but a genuine motion for the effective enforcement of accountability. When that is so, the distant but real possibility of being removed from office for good reason would serve the original and essential purpose of encouraging public office bearers to be accountable and fulfill their constitutional obligations. Each member must, depending on the grounds and the circumstances of the motion, be able to do what would in reality advance our constitutional project of improving the lives of all citizens, freeing their potential and generally ensuring accountability for the way things are done in their name and purportedly for their benefit. So the centrality of accountability, good governance, and the effectiveness of mechanisms created to effectuate this objective must enjoy proper recognition in the determination of the appropriate voting procedure for a particular motion of no confidence in the President. That voting procedure is situation specific. Some motions of no confidence might require a secret ballot, but others not. depending on a conspectus of circumstances that ought reasonably and legitimately to dictate the appropriate procedure to follow in a particular situation. The power to decide whether a motion of no confidence is to be resolved through an open or secret ballot cannot be used illegitimately or in a manner that has no regard to the surrounding circumstances that ought to inform its exercise. It is neither for the benefit of the Speaker nor his or her party. This power must be exercised to achieve the purpose of a motion of no confidence, which is primarily about guaranteeing the effectiveness of regular mechanisms. The purpose of that motion is also to enhance the enforcement of accountability by allowing members of Parliament as representatives of the people to express and act firmly on their dissatisfaction about the executive performance in between general elections. It is fundamentally for the advancement of good governance through quality service delivery, accountability, the strengthening of our democracy, and the realization of the aspirations of the people of South Africa. The exercise of the power to determine the voting procedure must thus always be geared at achieving the purpose for which that power exists. The procedure in terms of which the voting right is allowed to be exercised must brighten and enhance the prospect of the purpose for which it was given being better served or advanced. More importantly, the power that vests in the Speaker to determine the voting procedure in a motion of no confidence belongs to the people and must thus not be exercised arbitrarily or whimsically, nor is it open-ended and unguided. It is exercisable subject to constraints, the primary constraint being that it must be used for the purpose it was given to the Speaker, the facilitation of the effectiveness of Parliament's accountability mechanisms. Other constraints include the need to allow members to honor their constitutional obligations, regard being had to their sworn faithfulness to the Republic, and irrevocable commitment to do what the Constitution and the laws require of them for the common good of all South Africans. The Speaker is chosen from amongst members of the National Assembly. That gives rise to the same responsibility to balance party interest with those of the people. It is as difficult and onerous a dual responsibility as it is for members, perhaps even more so, given the independence and impartiality the position requires. But Parliament's efficacy in its constitutional oversight of the executive vitally depends on the Speaker's proper exercise of this enormous responsibility. The Speaker must thus ensure that his or her decision strengthens that particular tenet of our democracy and does not undermine it. There must always be a proper and rational basis for whatever choice the Speaker makes in the exercise of the constitutional power to determine the voting procedure. Due regard must always be had to the real possibilities of corruption, as well as the prevailing circumstances, and whether they allow members to exercise their vote in a manner that does not expose them to illegitimate hardships. Whether the prevailing atmosphere is generally peaceful or toxified and highly charged is one of the important aspects of that decision-making process. In conclusion, when approached by the UDM to have the motion of no confidence in the President voted on by secret ballot, the Speaker said that neither the Constitution nor the rules of the National Assembly allow her to authorize a vote by secret ballot. To this extent, she was mistaken. Our interpretation of the relevant provisions of the Constitution and the rules make it clear that the Speaker does have the power to authorize a vote by a secret ballot in a motion of no confidence proceedings against the President in appropriate circumstances. The exercise of that power must be duly guided by the need to enable effective accountability, which is in the best interest of the people and obedience to the Constitution. To the extent that the Tlowama decision might have been understood to have held that a secret ballot procedure is not at all constitutionally permissible, that understanding is incorrect. The Speaker's decision was invalid and must be set aside. Turning to remedy, this court has been asked to direct the Speaker, open quotes, to make all the necessary arrangements to ensure that a motion of no confidence is decided by secret ballot, including designating a new date for the motion to be debated, close quote. But no legal basis exists for that radical and separation of powers insensitive move. The Speaker has made it abundantly clear that she is not averse to a motion of no confidence in the President being decided upon by secret ballot. She only lamented the perceived constitutional and regulatory reality that she lacked the power to authorize voting by secret ballot. Meaning, now that it has been explained that she has the power to do that which she is not averse to, she has the properly guided latitude to prescribe what she considers to be appropriate voting procedure in the circumstances. It may be necessary to add that her counsel reiterated during the hearing that the Speaker is not really opposed to a secret ballot. The President's counsel also said that the Constitution neither requires nor prohibits, but in reality permits a secret ballot. He went on to say a secret ballot does not necessarily hold adverse consequences for the President. It would thus be inappropriate to order the Speaker to have the motion of no confidence in the President conducted by secret ballot, as if she ever said that she would not do so, even if she had the power to do so, and even if circumstances plainly cry out for it. To order secret ballot would trench separation of powers. Whether the proceedings are to be by secret ballot is a power that rests firmly in the hands of the Speaker, but exercisable subject to crucial factors that are appropriately seasoned with considerations of rationality. This court cannot assume that she will not act in line with the legal position and conditionalities as now clarified by this court. No legal or proper basis exists for that. In the result, we make the following order. 1, the United Democratic Movement is granted direct access. 2, it is declared that the Speaker of the National Assembly has the constitutional power to prescribe that voting in a motion of no confidence in the President of the Republic of South Africa be conducted by secret ballot. 3, the Speaker's decision of 6 April 2017 that she does not have the power to prescribe that voting in a motion of no confidence in the President be conducted by secret ballot is set aside. 4, the United Democratic Movement's request for a motion of no confidence in the President to be decided by secret ballot is remitted to the Speaker for her to make a fresh decision. 5, the Speaker and the President must pay the costs of the United Democratic Movement, the Economic Freedom Fighters, the eNCA Freedom Party, and the Congress of the People, including costs of 2 counsel where applicable. I hand down this judgment. The court will adjourn.